Islam, Shalom, Hola, Aloha, Bonjour, Osio, Assalamu Alaikum. This is your brother Zach Bay, Indigenous American Moor, coming to you live in full effect. Like, share, subscribe to my channel, hit that notification bell down below so you could be notified whenever I'm dropping new content. Leave a comment, interact with me. Thank you. I really do appreciate your viewership. We're jumping back into another one. Black's Law Dictionary, back at it again. Let's get it. All right, bear with me. Hopefully everything's legible. Hopefully you can see these definitions I have for you today. All right, so I want to start off with postal currency. Now this one was interesting because I actually didn't even know this, but it says during a brief period following soon after the commencement of the Civil War in the United States, when specie change was scarce, postal stamps were popularly used as a substitute, and the first issue of paper representations of parts of a dollar, issued by authority of Congress, were called postal currency. This issue was soon merged in others of a more permanent character, for which the later and more appropriate name is fractional currency. All right, yeah, so that was pretty interesting. I actually didn't even know that. So hey, they were using postage stamps before they could break a dollar. So if you just had a dollar bill and you wanted to get 50 cents, somebody would give you 2 stamps, and those 2 stamps would be a quarter each, and then you would just give them a dollar and you would have 50 cents along with some stamps. So that's pretty much how they're breaking it down. You could maybe 4 stamps for a dollar or something like that. Each stamp 25 cents, even though that's a heck of a lot of money for that time period, but just so you get what I'm saying. But let's move on here. Postal savings depositories. All right, so the act of Congress, all right, it was an act of Congress. It says created a board of trustees, the Postmaster General, the Secretary of Treasury, and the Attorney General to establish such depositories. All right, deposits may be made by any person of 10 years or over in his or her name, or by a married woman in her own name and free from her husband's control. Deposits may be made of $1 or multiples thereof, and any person may purchase for 10 cents postal savings stamps and attach them to a card furnished for the purpose, and a card with 10 stamps affixed will be accepted as a deposit of $1, or may be redeemed in cash, interest at the rate of 2%. A year is paid, but not on fractions of a dollar. No balance shall exceed $2,500. Deposits may be withdrawn or in whole or in part on demand. A depositor may surrender his deposits in sums of $20, $40, $60, $80, or $100, the multiples of $100 and of $500, and receive United States bonds of corresponding denominations bearing interest of 2.5% per annum, payable half yearly and redeemable at the pleasure of the United States after 1 year, and payable in gold at the end of 20 years. Very, very interesting right there. Very interesting. All right. Moving along. I thought this one was interesting as well. I've seen it before. This is called, it actually goes by other names depending on what state you're in, but it's called a poverty affidavit. Okay. So it says an affidavit made and filled by one of the parties to a suit that he is not able to furnish securities for the final cost. The use of the term is confined in a few states. Pardon me. All right. So if you have a suit, you're trying to sue somebody, you have a case, and you're filing paperwork, you're submitting documentation, and the court clerk says there's a fee to submit this paperwork. There's a documentation fee, there's a stamp fee, there's a record keeping fee, something like that, right? You do not have the finance to do it. They cannot turn you away legally. So you can fill out one of these poverty affidavits in order as a security for the final cost for you to file said paperwork. All right. Hopefully that makes sense. No, it might not be called a poverty affidavit. It could be called something else. All right, let's see. I thought this one was interesting. Law of corporations. All right. So what I noticed is this is pretty much like the same as person, but a artificial person. So a non-natural person, a legal person. All right. So it says law of corporations, the right or capacity to act or to be acted upon in a particular matter or in respects to a particular subject, as the power to have a corporate seal, to sue and be sued, to make bylaws, to carry on a particular business, or construct a given work. All right. I thought that was pretty interesting because the definition was pretty much like person, but corporate person. All right. Artificial person. And it goes under the law of corporations. All right. Power of attorney. I'm sure you've heard this term before, but now you get to see it in black and white. An instrument authorizing another to act as one's agent or attorney, also called a letter of attorney. All right. Very, very straight to the point. Nice and simple. All right. Practice. Repeated or customary action. Habitual performance. A succession of acts. Similar kind. A habit or custom. Usage. Application of science to the wants of men. The exercise of any practice. All right. So that's, the exercise of any profession. That will be a practice. All right. So let's see. Practitioner, he who is engaged in the exercise or employment of any art or profession. See what I mean? Practitioner, it says right here. Execution, the exercise of professions. All right. Rounding off here. I thought this one was interesting. Precautionary trust. A trust created by certain words which are more like words of entreaty and permission than of command or certainty. Example of which were of such words which the courts have held sufficient to constitute a trust are, all right, check it out. Wish and request. All right. So when those appear on documentations, or you can add those in your legal documentations, wish and request. All right. In fullest confidence. All right. Have fullest confidence. I've actually heard that one before, more recently. Have fullest confidence, or heartily beseech, and the like. That one sounds more medieval or classical. Heartily beseech. I beseech thee. All right. So precautionary words of entreaty, request, desire, wish, or recommendation employed in wills as distinguished from direct or imperative. All right, so when you see these words, it's distinguished from a direct or imperative terms, like something that necessarily has to be done, something that absolutely has to be done, or a wish that has to be carried out. These words in trust are more like, see, it says request, desire. So if you're reading the last will and testament of someone, and they say that I request that you spread my ashes into the nearest ocean or body of water, something like that, or I desire you take my remains to the top of a mountain, or something like that. You get what I'm saying? A wish, a recommendation. It's not necessarily a imperative, like only if you need to. All right, so precaution. I thought this was interesting. Last but not least, previous action, proven foresight, care previously employed to prevent mischief or to secure good results, or a measure taken beforehand, an active foresight designed to ward off possible evil or secure good results. All right, I thought it was pretty interesting that it says to ward off possible evils. Like, we're doing it just as a precaution. You know what I'm saying? Yeah, I thought those definitions were pretty interesting for today's Black's Law Dictionary. Hopefully it was helpful. You can pause the video to read it more closely, to get more of an understanding, overstanding, and understanding. Let me know how I'm doing in my videos. Comment down below, like, share, subscribe. Once again, this is your brother Zach Bay. Peace.